If you would, please state your name for the record and spell it, please.
My name is Ariane Andorfer, Arianeandorfer.
All right. And where are you employed?
I'm employed at the medical examiner office in Pearl.
And what do you do there?
I'm a deputy medical examiner.
And what kind of training or education does that require to do that?
So I'm a medical doctor. I went to medical school in Munich, Germany. And after graduating, I came here and did my medical residency in anatomical and clinical pathology at Henry Ford Hospital in Detroit. And then subspecialization in forensic pathology at the University of Michigan in Ann Arbor.
And Doctor, is it Andorfer? Am I saying it right?
Andorfer.
Andorfer? Are you board certified as well?
I am.
In what fields are you board certified?
Anatomical pathology, clinical pathology, and forensic pathology.
And in your career, how long have you been a forensic pathologist or medical examiner?
So I started my forensic pathology training in July of 2020, so since then.
And roughly in your career, how many autopsies have you performed?
About 1,300 now.
Your Honor, at this time, the state will tender Dr. Andorfer as an expert in the fields of forensic pathology, clinical pathology, and anatomic pathology.
Any objection from the attorney?
No objection.
She will be sorted. You may proceed.
Dr. Andorfer, did you perform an autopsy on Carlos Collins?
Yes, I did.
Your Honor, the defense had a pretrial objection related to certain autopsy photographs that we renew now. Might be it's hard to know which one specifically to object to, but renew the pretrial objection.
Please, if you would, please allow the court to review the photograph. I can't, the objection is too broad for the court to rule specifically counsel. If there's a specific photograph that you are objecting to, if we could have that marked for identification or something, that would be helpful, but I can't just respond to a global objection.
Understood, Your Honor. Then would it be possible to see all of the states that we came to?
Whatever he's about to admit, if
I
there
was just going to break them up in small groups, but if you want, please support however you button it.
I'm not sure how you all want to handle it, but I ask that you do so expeditiously and conveniently, so that we can move on. This is the court order, one, the ones that you want to object to.
Of course, don't, one second, try to get it back into the order. Approach the witness, Your Honor.
You know,
Dr. Andorfer, I'm handing you 21 photos, and I believe some of them have been previously marked for ID and some of them have not. But if you would take just a second and look through those photos. Are you familiar with those photos?
Yes, sir.
And how are you familiar with those photos?
These are photos that were taken during the autopsy.
Okay. And do these photos accurately represent the decedent as you performed the autopsy?
Yes.
Have these photos been changed or manipulated or altered in any way?
No.
Your Honor, at this time, the state would look to have these 21 photos admitted into evidence.
any objection other than the ones previously noted by the court,
No, Your Honor.
but they just so marked in there. And those marked by identification were moved in as an exhibit.
Let's see, number 132.
All right, Ms. Lefty, you may proceed.
Yes, Your Honor. Dr. Andorfer, I'm putting on the screen what's been marked previously as Exhibit 120. If you would, describe to the jury what that is and what we're looking at.
So on top there is an identification bracelet, which shows the county and the case number, which is medical examiner number year 24, case number 0342, and the decedent's name. And at the bottom, there's a little scale, which again has the medical examiner case number for this case.
All right, tell us what a scale is. Is it like a
It's
ruler?
like a ruler, and it's there to kind of give an idea of how big the wound is that we're trying to document.
Okay, so in most every photo, will we find that scale with the identifying case number?
Yes,
And we're putting on the screen what's been marked 121. Tell me what we're looking at there.
This is a so-called intake photo. This is a photo of how the decedent came to our office before any processing or anything was done. So this is how he was collected at the scene and how he arrived at our office before any autopsy or any procedure was done.
And I'm putting on the screen what's been marked as 122. Can you tell us what we're looking at there?
So this is an overview image of the decedent, which shows some of the wounds that we documented. So here is one of the sharp force injuries, namely a chop wound on the left upper back. And here you can see some of the gunshot wounds that we found on the right upper back of the decedent. And here on top, you can see a little bit of one of the gunshot wounds that were on his head.
All right, I want to take you back to the left corner, which you described as singular as a chop wound.
This one, yes.
Can you tell me the extent of that injury?
So this chop wound extended through the soft tissue, skin soft tissue, and also it left a curve mark on his left scapula, which is the bone right underneath it. So it went through skin, soft tissue, and bone.
And you just used the word curve, is that right?
Yes. Yes.
Explain to us what that is.
This is when a sharp instrument is hitting bone and it leaves like a mark in the bone, basically.
Okay, so this is a blunt force or a sharp force injury all the way down and cut mark into the bone.
That's correct.
Okay. So I'm going to put on the overhead what's been previously marked 123. And if you would, tell the jury what we're looking at there. Describe his injuries.
This is another view where you can again see this chop wound to his left upper back, but it also has another chop wound on his right shoulder. And here on top, you can see the chop wound that's to the top of his head. Here are, again, some gunshot wounds visible, and here are some of the gunshot wounds that were on his right upper back. Here you can see a little bit sort of better the depth of the injury of this one here.
And if you would, show me how many gunshot wounds we can see in this photo.
In this one, I see 1, 2, 3 to the head and 1, 2, 3 to the right upper back, but those are not all. This is just what you see in this view.
Okay. So I'm going to put on the screen what's been marked 124. Are you able to identify some, 124, are we able to identify some additional gunshot wounds in this photo?
Yes, so in this image, you see, I think all of them, 1, 2, 3, 4, 5, that were to his right upper back.
There were
Okay.
5 to his
Yes.
upper back.
Yes, and then again, this chop wound to his left upper back and some of the gunshot wounds to his head.
Now, do you know if those, into the 5 gunshot wounds we're looking at there, do they have exit wounds?
No, those were all related with projectiles or fragments.
So no exit wound on those,
No.
only an entrance wound?
Yes.
We're going to put on the screen what's been marked 112. And first, where is that scale that you talked about a minute ago? What injury is it under?
It's under the injuries to the decedent's mouth.
And what kind of injuries are we looking at there?
So there were multiple lacerations to the oral mucosa. So mucosa means the soft tissue inside the mouth, which you can see here. And then what we can also see in this image are an injury to his forehead and to his right eyebrow, and abrasions to his nose. So these two were sharp force injuries as well.
And the injuries to the nose, are there injuries on the external lips as well?
Yes, so this is an abrasion on the bridge of the nose, and then there's a little one on the side of his nose.
All right, and then as we zoom back out, tell me about the other injuries that you see in that photo.
In this photo, I see 2 gunshot wounds to the chest. One is related with a projectile, and one is a through and through, where the entrance is here and the exit is here. And then all these small other little injuries, there are little abrasions or lacerations, which I'm not sure the mechanism was for these. Could be like shrapnel injuries, or also little sharp force injuries or also blunt force injuries.
Okay. But laceration means that the skin has been punctured,
Laceration means the skin has been torn.
and so there would have been bleeding there as well.
Yes.
And you said some of these could have been caused from a projectile?
More shrapnel injuries, which means like a ricochet from, if a bullet hits the ground, it ricochets back to the chest and causes these injuries.
Okay, so shrapnel would be the parts of the projectile, little pieces or maybe even.
Either that or even when a bullet hits the ground and some little rocks go up to the skin.
Right. Tell us about the additional injuries in this photo.
There is a sharp force injury here across his chest, which is a superficial incised wound. So this went through the skin.
And I know this may sound elementary. Sharp force means with a sharp object.
That's correct.
So we take a look at 113, and specifically where your scale is. What is it that we're trying to look at in that photograph?
This is a gunshot wound to the chin, which went through the skin and soft tissue and left behind a few fragments.
And are we able to determine which way it started and which way it stopped?
No, the trajectory of this one is undetermined.
Okay. But it was a pathway of a bullet.
Yes, that was a pathway of a bullet because fragments were found inside the wound as well.
And this may actually show some of the injuries you described earlier just a little bit better.
Mhm.
The bottom left hand of his torso would be his right side.
Here.
Was that the injury that you just said a minute ago? Was it through and through?
That's correct. That's what I labeled as a through and through.
And where's the entrance side of it?
Here,
And where's the exit side?
this is the exit.
Now, what's been marked as 126? I want to bring your attention to that, and specifically where the scale is. What are we looking at there?
So these are injuries to his chin, mainly small lacerations and abrasions on his chin, likely related to blunt force injury.
And it appears, have you removed some of the beard to be able to
Yes.
see that?
Yes,
Okay. So all of these injuries were done at the same time, is that correct?
yes, they were all at the same time.
You don't have any reason to believe that any of these wounds were pre-existing on him?
No,
And if you would tell us about what we see on his right eye, it's a little better view in this picture.
this during autopsy appeared like a sharp force injury because it had smooth edges.
Okay? And then all of those wounds to his chin, what were those sharp?
Those were like lacerations, which means the edges weren't as clean as in a sharp force injury. So there are little tissue bridges when it's a laceration. Lacerations are from blunt force trauma.
And tell us what blunt force trauma means.
You were hit with a blunt object, basically, like it could be a hand or some other type of blunt object.
And I know in the last photo we just saw it, but is this in 127 just the close-up photo that your office took?
Yes, that's correct. It like shows these, the nature of these wounds a little bit better than the one that was further off.
Dr. Anderford, in 125, and I'm putting them now, and specifically we'll bring our attention back up to where the scale is. What is that we're looking at there?
This is another entrance gunshot wound to the left side of the decedent's neck.
That's an entrance wound,
That's correct.
gunshot wound.
Yes, entrance gunshot wound.
Okay, what else can you see that to the right and above it?
This is a entrance gunshot wound to the back of his head, left side.
That's an entrance wound to the left side back of his head.
Correct.
All right, and above his right, or above his left eye, what
Yeah.
can we see on Mr. Collins?
So this during autopsy was also looking like a sharp force injury, meaning it had smooth edges on inspection.
Okay, and then right here at the top of his chest, close to his collarbone area, is that some of those, marks and cuts that you were talking about that could have been from shrapnel?
Correct, yes. This could be, like I said, it could be shrapnel, it could be like abrasions from blunt force trauma and lacerations, so that's hard to tell because they're superficial injuries.
Now, on 128, what part of Mr. Collins' body are we looking at now?
We're looking at this part of his head, which is, you can't really see it very well in this image, but this is one of the chop injuries that he sustained, and it's the one that's like on top of his head.
And is it hard to tell because his hair?
Because his hair is still there, yes.
So I'm gonna put on the screen what's been marked 114. Is this the same photograph of him,
Yes.
just with his hair removed?
Yes, this is, after the hair was shaved off to actually show the wound better. And this wound actually went through his scalp and also left a curve mark in the bone, in his skull bone, so that basically went all the way through his skull bone. It did not go inside the brain, but left a mark on the skull, so significant force.
And that's on the top of his head?
That's correct, it's right,
To the right.
yes.
Now I want to show you what's been marked as Exhibit 115. And where the scale is on that, can you tell us what we're looking at here?
These are additional small abrasions and lacerations that we also saw on his chest. So these are again superficial skin injuries there.
And then State's Exhibit 116. Can you tell us what we're looking at there?
This is the chop injury to the top right shoulder. And this one, you can also see that it went pretty deep, but this one is skin and soft tissue.
This one did not leave a curve mark on this one.
No, it didn't hit any bone, this one, just pretty deep into the skin and soft tissue.
Now, just as a reference, we're looking at some of these photos. How tall was Mr. Collins?
Real quick, I have the first one before. 74 inches.
And is that 6 feet 2 inches?
Yeah, I think thereabouts.
And how many pounds do you weigh?
He weighed 224 pounds.
And an incision like, or a laceration like that, how big is that scale?
This is about 2.5 inches, so I would say the wound itself is about 2 inches.
And I want to take you to what's been marked, Exhibit 129. Explain that photograph to us.
These are gunshot wounds to his left, to the left back of his head, before shaving them. So you can see, you can't see them very well because there's still the hair around it.
So that's the back of his hair.
That is the back of his head on the left side with hair still around the wounds.
I'm going to show you what's been marked 117. We'll zoom in. Does that clearly show, or explain that photograph to us?
You can see gunshot wounds here with the hair shaved off. So it's a better image of the previous one. And here again, you see this deep chop wound on his left upper back.
How many gunshot wounds can we see in this photograph to his head?
We'll come back to our report. We see 1, 2, 3.
And if you could point those out with your pointer too.
Here.
All right.
And this here appears to be one exit wound.
And I'm going to show what's been marked 118. Zoom back out. 118. And if we'll draw your attention specifically that marker, we'll look at that there.
This is one of the entrance gunshot wounds, which was to the top of his head with the hair still around.
And then I'm going to put on the overhead 119.
These are 2 gunshot wounds to the right side of his head, to the back.
Those are entrance wounds.
Those are entrance wounds.
How many times was Mr. Collins shot in the head?
He was shot in the head 5 times. So when we had the previous picture of the left side of his head, I believe one of those was an exit wound, an additional exit wound. So there were 2 exit wounds and 2 entrance wounds on the left side of his head.
And he was shot 5 times in the head.
He was shot 5 times in the head plus 1 more time in his chin. So that also kind of counts as the head.
So 6
Yes.
times this.
Mhm.
And these we're looking at were all to the back of his head.
Correct.
With the exception of the graze under his chin, the other 5 were all to the back of his head.
That's right.
Dr. Anderson, I'm putting on the screen what's been marked 130. Can you tell us what we're looking at there?
These are multiple small additional abrasions and lacerations on his left forearm. And these, the mechanism of these is also not really clear. This could also be like ricochet or sharp force injuries or blunt force injuries here. Because these are, like I said before, like very superficial. So mechanism is not clear.
But these are cuts and lacerations
That's right.
all down his left forearm, all the way up to his head.
That's right.
And then 131, tell me what we're looking at there.
This is a little laceration with surrounding contusion on his first digit of his left hand.
So continuing that other photograph down his left forearm, he's got another laceration or cut on his left hand.
Correct.
And then picture 132, you will tell us what we're looking at there.
This is another laceration on his left hand, on the thinner eminence, which is here.
So another cut on his left hand.
That's right.
Dr. Anderson, not only do you look at the outside of the body and determine the entry wound, several of these had entry wounds with no exit wounds, is that right?
That's right.
Do you then go into the body and retrieve projectile fragments or projectiles?
Yes, that's what we do.
Your Honor, may I approach the witness? Your Honor, may I approach the witness? Dr. Engelfer, I'm handing you a stack of photographs. Have you seen those photographs before?
Yes, sir.
And what are those photographs of?
These are photographs of the projectiles and fragments that were retrieved from the decedent's body during the autopsy.
And have those photographs been changed or altered in any way?
No, sir.
Do they represent the fragments that you retrieved from the body?
Yes.
Your Honor, at this time, the state moved to have these photographs admitted into evidence.
Any objection?
Okay, Your Honor.
Maybe so marked in blue.
The last one was 149. The last exhibit was 149.
So 133 to 149.
Yes.
Can you see what we need to
seen those before?
Yes, sir.
And what are those that we're looking at?
These are the little evidence bags where we put the removed fragments and bullets in that we took from the body. And we submit them for evidence this way.
So those are the actual fragments or projectiles recovered from the body, placed first into the middle envelope
Yes,
and
and
then
then,
in the plastic bag.
that's right.
And are those sealed and have crime lab initials from it, from the
Yes.
medical examiner's office?
Yes, they do again have the case number, the county, the name of the decedent, and the location where we retrieved them from.
Your Honor, at this time, the state would move to have these admitted into evidence.
Exhibit,
There may be 16 total. One second, Your Honor.
I'm just asking, you want to have an individually number, or did you want to have a number that's just one exhibit number 150 with 16 parts?
Individual.
Let's take a break while she does that. I'm not gonna go sit and watch her while she does it. Tell me for 2 days while she does it. I think I'll let you do that.
All right.
I consider it imaging. What do we have? No, they have to be in order, because they're H, all the way to X.
Sure, Dr. Copeland.
They're all letters, so they're gonna be in.
You don't need to see it.
Yeah, the last one is, H through X. Put them back in.
150 through 166. And they're alphabetical, so they're A through, is it H? Is it H?
150 through 166,
It's
and on the
H.
front side, it's H through X.
X, H through X.
This is 166.
Uh-huh, so it's 166. So it's H through X.
You need to send it to organize the photos and read it.
If you're on.
You can adjourn.
All right.
Jared's in the courtroom.
Thank you. All right, ladies and gentlemen, you all may be seated. Thank you for that, we may proceed.
Dr. Anderson, what's been previously marked in what is 133, I'll first read it through. If you would, tell us what we're looking at there. First of all, let's look at the envelope. Tell us what that is and what that represents.
So, this is again labeled with the case number, medical examiner case year 24, case 342, county, Pines County, the decedent's name, and here is the location, which means, so this is a fragment that we retrieved from the buttock.
So that's 001-H.
Yeah, this is what we labeled the evidence, this evidence by letters H.
Okay. And is that the fragment that was recovered?
Yes,
And then in exhibit 150, is this the actual piece of paper with that fragment in it?
that's correct. This is the envelope where the fragment was put in. The same sticker that we saw before, and it's in a plastic bag, also with the identification sticker and all the labeling that I described before. And here's a yellow tape that I have personally signed and dated.
And then exhibit 134. Tell us what we're looking at there.
This is again all the identifiers that I explained before, and these are, can you make that a little bit?
Absolutely.
Yeah, thank you. Okay, fragments from the chin. So these are fragments from the contract wound to the chin that we showed before.
And what letter is that?
I,
And in exhibit 151, are those the actual fragments?
Those are the actual fragments that are bagged in that paper bag and in the plastic bag, and again with all the identifiers on the paper bag and the plastic bag and the yellow tape that has my signature and the date.
And in exhibit 135,
Again, the same case identifiers, letter J, and this is the location, this is a bullet from the left lateral chest, which means left side of the chest.
and in exhibit 152, is that the actual bullet that you recovered?
That's correct, that's the bullet packed up in the plastic bag and paper bag and all the identifiers and everything.
And that's what was recovered from his left lateral chest.
Correct.
And then 136,
This again has all the case identifiers, letter K, and this is a bullet from the anterior inferior chest. This is again the location of the bullet.
and in exhibit 153, is that actual bullet we just saw a picture of?
Yes, K bullet from anterior inferior chest and all the case identifiers and the tape that I signed.
And in exhibit 137,
This is a bullet from the anterior superior chest. Again, all the case identifiers, letter L.
and in 154, is that the actual bullet?
This is the actual bullet in the paper bag, plastic bag with all this identifying stickers and the tape that I signed.
And in exhibit 138,
This is a bullet from the left lung with the letter M and again, all the case identifiers.
and in exhibit 155, is that the actual bullet?
This is the actual bullet from the left lung in the paper bag, plastic bag, all the identifying stickers and the tape that I signed.
Exhibit 139,
This is letter N, a bullet from the inferior sternum. Again, all the case identifiers on the sticker.
and in exhibit 156, is that the actual bullet?
Yes, this is the bullet from the inferior sternum with, in the paper bag, plastic bag, all the stickers and the tape that I signed.
And then exhibit 140, what are we looking at there?
These are bullet fragments from the left chest cavity, case identifiers, and letter O.
And then exhibit 157, are those the same fragments, letter O?
That's right, in the paper bag, in the plastic bag, fragments from left chest cavity with the bullet tape that I signed.
Exhibit 141, what are we looking at there?
This is a fragment from the abdominal cavity, letter P with case identifiers.
And in exhibit 158, is that the actual fragment, letter P?
Yes, this is the fragment from the abdominal cavity, paper bag, plastic bag, letter P, and all the case identifiers and the bullet tape that I signed.
Exhibit 142,
These are fragments from the right shoulder, labeled letter Q. Yeah. Letter Q with all the case identifiers of the decedent.
and then exhibit 159, is that the actual fragment, letter Q?
Yes, those are the fragments, letter Q, paper bag, plastic bag, case identifiers, and bullet tape that I signed.
Exhibit 143. What are we looking at there?
These are scattered fragments that we retrieved from the brain. Again, all the case identifiers in the letter R.
And then exhibit 160.
These are the same fragments from the brain that are in the paper bag, plastic bag, bullet tape, and all the case identifiers.
Exhibit 144.
This is also a bullet from the left frontal lobe. This is also from the brain. Again, has all the case identifiers, and this is probably letter S.
Letter S.
Yes.
And in exhibit 161, is that the bullet from the brain, letter S?
That's correct. In the paper bag, plastic bag, bullet tape, and all the identifiers.
And then exhibit 145.
This is also a bullet from the brain, namely right frontal lobe, letter T, case identifiers on the sticker.
And on exhibit 162, is this letter T?
This is letter T, the bullet from the brain, right frontal lobe, again with all the case identifiers, stickers, paper bag, plastic bag, and the bullet tape.
Exhibit 146.
These are fragments from the occipital head, letter U. This is again the sticker with the case identifiers. So this means back off the head.
So these were in the brain also? Or were these in the bone?
No, these were probably either in the bone or in the skin.
And then exhibit 163, is that the fragments U?
Yes, these are the same fragments, letter U from the occipital head, plastic bag, paper bag, bullet tape, and all the case identifiers.
Exhibit 147.
This is a fragment from the left scalp, which means the skin on the head, letter V, case identifiers.
And is 164, letter B, that actual fragment?
Yes, that's the fragment from the left scalp and the paper bag, plastic bag with all the identifying stickers, and there's a little bit of the bullet tape visible.
$148.
This is letter W. Those are fragments from the right posterior neck, which means it's the right back of the neck. And the case identifier sticker.
These were fragments in the right side, back of the neck.
Correct.
What letter are they?
W.
And exhibit 165,
These are the same fragments from the right posterior neck, so right back of the neck, letter W in the paper bag, plastic bag, case identifying stickers, and bullet tape.
and exhibit 149.
This is letter X. This is a bullet from the cervical spine. So this means that this is a bullet from the top of the spine up here.
And that's letter X.
Yes.
And exhibit 166, is that the actual bullet from the spine?
This is the same bullet, which is in a paper bag, plastic bag, case identifiers, and sealed by bullet tape.
Dr. Anderson, many times was Carlos Collins shot?
He was shot 15 times.
I'm sorry, 15?
Yes, 15 times.
How many times was Carlos Collins hit with an axe?
So
How many chop marks did he have?
he had overall 6 sharp force injuries, 3 of which were actual chop marks, and the other ones were either chop marks or superficial sharp force injuries through the skin.
Now, out of the 15 gunshot wounds, how many were to his head?
6 were to his head.
How many were to his neck?
1 was to his neck.
How many were in his back?
5 were on his back.
In his chest
He had 2 to the chest
and right shoulder?
and 1 to the right shoulder.
Now, tell me how many chop and sharp force injuries did he have to his head?
To his head, he had 3.
To his chest,
1,
right shoulder,
he had 1.
and his back?
His left upper back, he had 1.
Now, did he also have other abrasions and cut marks
Yes.
and lacerations on his body?
Yes, so he had multiple abrasions and lacerations to his face, chest, and his extremities, mainly arms and hands.
Extremities being his arms and hands,
Yes, arms and hands.
and also to his mouth.
That's correct.
And was a toxicology done in this case as well?
Yes, toxicology was done and it was negative.
Dr. Andorfer, were you able to determine the cause and manner of death?
Yes, I was.
What was the cause of death?
The cause of death was multiple gunshot wounds.
And what was the manner of death
The
for
manner-
Collins?
The manner of death was homicide.
State tenders the witness, Your Honor.
Afternoon, doctor. So, doctor, if I understand your testimony, the cause of death was gunshot
That's right.
wound. And is there any medical determination of the sequence of those gunshot wounds?
No, there's no determination of the sequence of the shots.
So medically, you didn't determine if the shots to the front came before or after the shots to the back.
No, you cannot medically determine that.
And the sharp force injuries, did I understand you to say that only 3 were considered significant?
I mean, that went actually deep into the tissue, yes.
And in your report, is it correct that you determined that the sharp force injuries and the abrasions and the lacerations were non-fatal?
That's right.
So these chop force injuries were not by themselves fatal?
That's right.
And your job as a medical examiner is to make a medical determination, not a legal determination, correct?
That's right.
So can you explain a little bit, when the manner of death is determined to be homicide, what does that mean in medical terms?
In medical terms, the manner of being homicide means it's via the intentional actions of another person, so basically at another person's hands.
But medically, you don't know any circumstances leading up to that, other than what you can observe just on the body itself, correct?
No, I wasn't there. I can only document the injuries that I've seen on the body.
So medically, homicide is not a legal determination, one way or the other, whether this death was justified or not.
Yeah, it's only a medical determination.
Thank you, that's all I have.
Any regret?
No, Your Honor.
I guess I'll recess for about 15, 20 minutes, which I read. All right.
Jury's out of courtroom.
Court being recessed. Right, you all may be seated. At this time, the state may call you next witness. Let's take a break. All right, ladies and gentlemen of the jury, I know you're gonna feel confident, I can come in, sit down and get back up, but that's exactly what you're gonna have to do. The state has now rested their case in chief. There are some matters I need to take up, prior to the defense beginning their case, but they have indicated they are going to begin their case in chief, this afternoon. Now, you have not received all the evidence in this case, nor have you received instructions of law, nor the closing arguments of counsel, so we are not finished yet, but we're probably are not going to finish today. So I do expect that, we will take up the defense case in chief, and probably tomorrow, we may start a little later, but I'll look at it once we see what we're about to talk about. But for now, hopefully you get too comfortable, because I do think this speech you all the Thank you.
All right. Jury out of order.
All right, you all may be seated. All right, at this time, the state has now rested their case in chief. What says the defense? Are you ready to proceed, or do you need a moment?
That's very procedural.
All right, you may proceed.
That was intended to call.
Uh-uh.
Defense intends to call the defendant.
Well, did you have any motion or anything prior to that?
Yes, Your Honor.
I know, it's been a long day.
Yeah.
We got rather warm in this courtroom. I've talked to the board of supervisors about that, because sometimes the fan makes it difficult for my court reporters to be able to hear clearly. So I think we all got a little bit dressed.
Yeah, but thanks for reminding me. The defense would move for a directed verdict at this time based on the fact that we do not believe that the state proved the element in count one, that this was a deliberate design, and, or did they prove that this was not self-defense, since that has been alleged. As for count two, we proved that we would move the directed verdict on the basis that did not prove that this was willfully fired into the residence, according to the or that it was unlawful in light of the self-defense that has been brought to the table.
Who says the state?
Your Honor,
I'm going to need
I'll
you
listen.
to the podium so that we can make sure that it's recorded properly.
Yes, Your Honor. Your Honor, I know the court is well aware that the standard for a directed verdict is that all inferences, all reasonable inferences should be decided in favor of the non-moving party, which would be the state in this situation. So the first element that the state has to prove is that this occurred in the first judicial district of Hines County, and that it occurred on April 9th, 2024. We've had several police officers, starting with Detective Crime Scene Investigator Harris, as well as Detective Geis, as well as the neighbor across the hall, Tony Milligan, who all had stated that the 6303 and 6304, which are the two apartment complexes, or two apartment rooms that are in question, are in the first judicial district of Hines County. Furthermore, we have to prove that it was a human being and that Carlos Collins was a human being, was alive on that day. We've been able to prove that, one, through the surveillance video that was obtained and introduced through Detective Geis, and also through the proof of life that his mother had came up and testified that he was alive, and showed pictures of him and had been in contact with him prior to that day. Furthermore, the defendant has been identified through the surveillance video. He's also been identified in his own interview statement. He's been identified by the detective that both witnessed the surveillance video and also interviewed him and ID'd him through those photos. Also, he was apprehended in the vehicle and was identified by the trooper, Hanson from Louisiana. And the next stage is we start talking about with deliberate design. And so we do malice aforethought. Malice, there's a permissive inference that jurors are allowed to draw when a deadly weapon is used. And deadly weapon has been proven. There has been facts that come forth in this trial, evidence of the use of deadly weapons. Therefore, very reasonable minded court could determine that malice aforethought was there just based on the use of a deadly weapon. However, there is facts and other things that come into play, and they can make that determination that there was malice in other ways, such as the amount of times that were shot and the use of an axe. Clearly, the fact that the defendant had defensive wounds on his arms and hands, and that he had injuries to his head and back, and that he was shot multiple times in the back of the head and the back of the neck, the back of the back. That would indicate that he was not in any way advancing towards the defendant when he was injured or hurt, because it would be a reasonable inference for a jury to determine that he obviously had his back to him in order to get shot in the back, and that his back was to him getting hit in the back with an axe and on top of the head. So these injuries itself can speak for themselves as to how they were obtained. Also the video, the surveillance video that brought forth, for argument's sake only, would be able to show that there was a break. It was not a continuous action that was going on. There was actually a break that occurred. The incident actually started inside the apartment, which is obvious from the photos. There's blood inside the apartment in the hallway. However, it escalated and then continued to go outside into the hall. So for argument's sake only, if we just disregarded whatever occurred in the apartment complex, once the axe was retrieved, wrestled away from Marcus Johnson by Carlos Collins, he did not advance towards Marcus Johnson. He then left, turned away, went across the hall to the other apartment, banged on the door trying to retrieve help. Marcus Johnson also left that scene, went inside, retrieved his firearm, and then came back to the situation to try to claim that he needed self-defense. So it is true that a reasonable minded juror can look at the surveillance video and make a determination that if they did believe at any point in time that the defendant made at any time, if the victim was actually the one that came forward with an axe, that he had abandoned any plan or design to injure or threaten the defendant. And thereby, by his abandonment of that, but then the defendant leaving and coming back to the situation pre-armed would have created him being the initial aggressor of the second act that occurred. And that's just for argument's sake, Your Honor, because we believe that the facts that are shown, as well as the injuries to the individual, as well as the actions that occurred out in the hallway, speak volumes that that the initial aggressor was from the beginning Marcus Johnson. He always had been. He's the one that grabbed the axe and initiated all this. He's the one that implemented all of the injuries to Carlos Collins, and he is the one that has absolutely no injuries again. So it's fair for a reasonable minded juror to believe that he was on the handle end of the axe, thereby receiving no injuries, and Mr. Collins was on the blade end of the axe, receiving all the injuries. Of course, indulge, Your Honor. Your Honor, that concludes all of the elements to first degree. The reasonable minded juror, if they take all those facts in that these witnesses have brought forth, they could determine that this was a willfully and with malice aforethought killed Carlos Collins by shooting him with a firearm, and that it was not necessary self-defense. The next count that he is charged with is shooting into an occupied dwelling, and there's been plenty of evidence as to the location and date. Your Honor, will come forth from several witnesses. And it's willfully and lawfully shot or discharged any pistol, shotgun, rifle, or firearm of any nature or description into any dwelling house or any other building usually occupied by persons, whether actually occupied or not. And that's important to say because Marcus Johnson has, by his own admissions in his interview and seen on the surveillance tape, he did willfully shoot and discharge the pistol into a dwelling house. Because we've got the photos where the bullets go into the dwelling house, we got the photos where they hit the interior walls, and he did willfully shoot that. So it would be a determination for the jury to determine what's an unlawful shooting. So that's the next step, is willfully and unlawful shot. So if the jury determines, because the facts have been put forth, that he did not act in reasonable self-defense, then he would have been unlawfully shooting at that time. So there's been enough information brought forth to the jury to make that decision.
All right, so before the court at this time, this motion, defense motion for the directed verdict as to counts 1 and 2, and approximately 24,616. In count 1, the defendant is charged with first-degree murder by deliberate design, and in count 2, he's charged with shooting into a dwelling. In order, the court requires on a motion for directed verdict that the court should consider all reasonable inferences that may be drawn from the evidence at this point, and to consider those as acceptable as true. In this instance, the state bears the burden of establishing that on or about April 19, 2024, that the defendant did willfully and lawfully and feloniously murder one individual known as Carlos Collins with an unknown caliber firearm within the jurisdiction of this court. In this instance, the state has established, first and foremost, that the events alleged did occur within the First Judicial District of Hinds County, Mississippi, having occurred at 120 Parkway Drive, which is located in Jackson, Mississippi. The state has established that Carlos Collins was a human being at or around the time the events occurred. The state has produced a sequence of information in regard to the circumstances of this offense. The police were dispatched on the evening of April 9th to 120 Parkway Drive, where they came upon a person later identified as Carlos Collins, who was at that time already deceased, suffering from several physical critical injuries. The individual was naked and was lying on top of what was later determined to be a very long axe blade. It was later determined through evidence that the neighbor to Mr. Collins, who lived in apartment 6304, had heard several loud noises that sounded somewhat similar to gunshots and was not aware of what came up at that time in the morning to those events, but upon opening his door, found the person of Mr. Collins lying deceased at the doorway, having succumbed from the injuries. At the time of the event, there were no other witnesses to the event. However, there was a green camera video, which the state introduced into evidence, that showed a portion of the events. It showed the decedent leaving his apartment, struggling with another individual, trying to gain access into his neighbor's apartment, and that he was visibly bloody, visibly injured, There did not appear that there was any injury to the other person, although the back of that person was seen on the video. In the video, you do see the decedent and the defendant struggling with the weapon, which was later determined to be the axe blade. And eventually, the victim was the last person to have the axe blade in his hands, at which point the other person appeared to not be seen on the camera. The decedent was seen turning and knocking on the door to apartment 6304 in what would appear to be not an aggressive move towards anyone and not engaged in the activity. And then within a few seconds, the other person in the video, who was not at this time identified, is seen with a firearm, which caught the attention of the decedent. As he was struck, he fell, he was naked, he was bloody. He fell on top of the blade, and you see the other person fired several times into the person of the decedent as they lay on the ground, not attacking that person at that time, and certainly not in a position from what we see on the video to have caused the other person being injured. Then you see the person approach the prone body of the decedent and fire additional shots in what appeared to be the head area of the decedent and leave the scene. The state later will produce evidence through Detective Dice as to the identity of the suspect, a person of interest in this matter, who was later apprehended 2 days later in Louisiana after a BOLO was issued for a person in a vehicle identified through their investigation. We heard testimony from Trooper Henson, who identified the person that he saw in the vehicle that the Jackson Police Department was looking for. It was identified as the defendant in this case. The state produced evidence at that time of the contents of the vehicle and were able to locate a firearm that was possibly used in the altercation that occurred 2 days before. The state also produced evidence in regard to a shirt, presumably with bloodstains on it, that had been worn by the defendant, but it was located in the rear area of the car. The state did produce also a statement from the defendant whereby he waived his Miranda rights, considered to give a statement. He was not under the influence of any drugs or alcohol. The court did not, and he gave a statement to the Jackson Police Department. It was then noted at that time that the defendant was an officer of the Jackson Police Department, whose statements he made during his interrogation, wherein he also acknowledged that he had taken a firearm that was once in his possession and had found it at a location in Jackson, Mississippi, USA. The state did produce evidence that they had recovered that firearm that was pawned by the defendant. The court will note that the receipt was found torn in the vehicle, which might indicate an intent to try to destroy corroborating location information as to the firearm, but was unsuccessful. The court did hear, as well as the jury, the statement made by the defendant in this case. And the court does note to the parties that the self-serving statements made by the defendant during his interrogation are insufficient to put forth to the jury the question of self-defense. The defendant's statement is taken in light of the defendant does place himself at the location at the time of the incident, that he was involved in some sort of altercation with the defendant. And therefore, based on all of the evidence that the court has heard at this point, the court is of the opinion that the state has put forth sufficient evidence to put forth to the jury the question of whether or not the defendant should be found guilty of first-degree murder in count 1, primarily due to the lethal injuries that occurred to the defendant, to the victim, in that there were 5 gunshot wounds to the head area. The other injuries were not noted as lethal injuries, but they do show an intent to cause fatal harm to the decedent. As to count two, the defendant is charged with shooting into the dwelling, being as a result of the shells and shots that were found in the apartment door. The court does note that the initial shots that were fired at a time the defendant may not have appeared on the camera, but it did catch the attention of the victim or the decedent as he was knocking on the door and then overturned as he was being fired upon. The court, knows that the, considering where the victim was placed at that time and where the defendant would have known that when he was shooting at a door or at another apartment at the time he was firing at the defendant, if the jury believes the defendant is responsible for these acts. The court will then find that there is sufficient evidence in this incident to charge the defendant with shooting into an occupied dwelling in count 2 of the indictment. And there is sufficient evidence has been submitted such that a juror could find the defendant, to put forth to the jury the question of whether or not the defendant should be found guilty in count 2. Now, at this time, before the jury is brought back in, before the defendant makes any decision as to whether or not he is to testify, the court is required to advise the defendant of his rights. At this time, I ask Mr. Culpepper and Mr. Johnson if they please come forward. All right, in Culbertson versus State, the Mississippi Supreme Court instructed the trial courts of the state to make a record of the defendant's waiver of his right to testify. At this time, Mr. Johnson, I want to make sure that you understand that the law gives you certain rights. In particular, I want to discuss with you your right to testify. You do have the right to take a stand and testify in your own defense. The law also gives you the right not to testify. You don't have to testify, and you don't have to offer any evidence at all. The burden of proof is on the state. You have both of those rights. If you choose not to testify, the state can't comment on it. They can't comment to the jury or point out the fact that you did not take the stand and testify. However, if you do testify, you will be subject to cross-examination. Just like when the state put on witnesses, your attorney had an opportunity to cross-examine them. And if you took the stand, the state would have an opportunity to cross-examine you. The choice as to whether or not you wish to testify is yours to make. But once made, can't be unmade. In other words, once you take the stand and testify, you can't then decide that you don't want to testify. And if you give up the chance to present evidence, once your side rests, you can't decide then, oh, I want to testify. Once the case is over, the decision has been made. Do you understand those rights and what they mean?
Yes, ma'am.
The decision is yours alone to make. You should make it after consultation and discussion with your attorney. But it's ultimately your decision. Do you understand?
Yes, ma'am.
I am going to give you a chance right now to consult with your attorney. Then I'm going to ask you whether you will testify in this trial or not. Do you understand? I don't know if you all accept it or not.
Yes, ma'am.
At this time, I'll give you a moment to confirm. You'll let me know when you're ready.
We've had a chance to convert, Your Honor.
Mr. Johnson, will you be testifying in this matter?
Yes, ma'am.
All right, let me just tell you all this. It is now 4 o'clock. And in my experience, usually when the defendant decides he wants to testify, it doesn't take more than an hour. I don't, but this room is hot. Everyone is uncomfortable, so you're going to be the benefit of having to present your testimony in the morning, okay? So we're going to call the jury back in. I am going to excuse them for the remainder of the day. And is he somewhere available where you can receive this talk that is prepared?
Yes, ma'am, yes.
All right, so let's bring the jury in. I'm going to excuse him for the day, and he will start at 9 in the morning. You two may be seated.
All rise.
Thank you. All right, ladies and gentlemen, you all may be seated. I want to thank you all for your patience on particular those matters. The defense is going to begin their case in chief, but it is now 4:00. I'm not gonna keep you here. You're all tired, and I made that decision to run one out, to allow the defense to start their case fresh in the morning at 9:00. They do have witness here today, participate, that may be better than me. And I don't think that we can finish it in 1 hour that we have left this afternoon. So I am going to excuse you for today. Now, you're still under the same instructions that I gave you on Tuesday. That is, you are not to go on to watch the news this evening. You're not to go on any social media accounts, and you're not to discuss that you are a juror on this case. You want everybody to understand that? If someone should ask you about that, how you feel, how you can't discuss that, at this time, you do not have all the evidence, and your duty is to discuss amongst yourself. Once you have all the evidence, the law, and the arguments. So with that, you have a perfect afternoon. I'll see you all tomorrow. Thank you so much.
All rise. Good,
Thank you. You all may be seated. Give you a couple seconds to get out of the building. But with that, court be adjourned until tomorrow. Is there anything we need to take up first to say? No. You all return all exhibits to the court, to the court. Yes, sir.
Yes, Your Honor, I was gonna take a minute when court allowed me to just go through them all.
Okay.
We should have everything in there.
Mr. Cutler, is there anything we take up?
Nothing to do with that, sir.
Thank you. I'm sorry for that the room is so uncomfortable. I am going to speak to the board about that. I told them yesterday to make sure that we had a problem and they didn't get any better. All right, if there's nothing further, court will be in recess until tomorrow. The waiters will let everyone know when they think that the jury's heard, about it, on their way out of here. Thank you.